This is ABC News legal analyst Royal Oakes welcoming you to Hinshaw and Culbertson's Insurance Law Program, where we discuss insurance and reinsurance issues of interest to industry professionals. Here's your host, the co-chair of Hinshaw's Global Insurance Services Practice Group, Scott Seaman.
Hello, everyone. Thank you for joining us on Insurance Law. I'm Scott Seaman, and on this episode, we'll discuss a couple of interesting fax blasting and ransomware coverage cases. And we're fortunate enough to have as our guest once again, Shane Dilworth, the senior reporter and our favorite guest from Law 360. He does an outstanding job handling the insurance law beat. Shane, great to see you again.
Thanks for having me, Scott. It's always a pleasure.
The first case we're going to discuss is the Yahoo case from the California Supreme Court. It's a fax blasting case, and it has some potentially broader ramifications in terms of coverage B and the right to privacy. Shane, if you could begin by giving us a brief overview of the facts of that case.
Absolutely. In 2017, Yahoo sued its insurer, AIG Unit National Union Fire Insurance Company of Pittsburgh, seeking a defense against 5 putative class actions over alleged violations of the Telephone Consumer Protection Act, or TCPA. The underlying plaintiffs complained that Yahoo sent customers unsolicited text messages. A California federal judge tossed the case after finding that the insurer had no duty to defend since none of the complaints alleged disclosure of confidential information to third parties. Yahoo appealed the dismissal, and the Ninth Circuit certified a question to the California Supreme Court for guidance on whether liability insurance covers TCPA claims under state law.
And what did the California Supreme Court hold?
The Golden State High Court found that the duty to defend could be triggered based on ambiguity in the policy language and the reasonable expectations Yahoo had when purchasing the policy. Typically, policies similar to those purchased by the tech giant do not include coverage for alleged TCPA violations. However, Yahoo added an endorsement that could cover such acts. The California Supreme Court concluded that even though the added endorsement in the policy was customized to fit Yahoo's needs, the language was drafted from a standardized form. As a result, the insurer could be considered the author of the policy, and ambiguities could be construed in favor of triggering the duty to defend.
Yeah, the California Supreme Court seemed to really strain itself to find an ambiguity. But what do you think is the significance of the decision within the state of California and perhaps elsewhere?
I think this ruling will have courts taking a closer look at the applicability of contra proferentum, as well as the sophisticated user doctrine, since Yahoo was a large company who employs individuals with knowledge on how to draft a policy that would cover potential liabilities.
Yeah, as I alluded to, I don't know that this was the best work by the California Supreme Court, but certainly it'd be a decision that policyholders will call upon on a bunch of privacy-related coverage cases. The second decision is a silent coverage decision from the Ohio Supreme Court on December 27th of 2022, saving probably the most important decision on coverage from that court to the end of the year. This was a so-called silent coverage decision. What type of policy was involved?
The policy at issue was a business owner's insurance policy that included an endorsement for software, which provided coverage for direct physical loss or damage to media.
And in case I didn't give it earlier, it's the EMOI versus Owners Insurance Company case. And just if you could just give us the salient facts.
Sure. The policyholder sued its carrier, Owners Insurance Company, in Ohio State Court after coverage for damage to the software was denied. The trial court judge initially entered summary judgment in favor of Owners, but an appellate panel overturned the ruling after finding that EMOI potentially suffered physical damage to its software.
And what did the court rule?
In its December ruling, the Ohio Supreme Court reversed the appeals court's ruling after finding that software cannot suffer tangible physical damage.
And what's your take on the significance of the decision?
I think the big takeaway from this is going to be how courts interpret how and if items such as software can sustain physical loss or damage, and if non-cyber policies can provide coverage.
So far, there have been more court rulings on so-called silent cyber cases under traditional property policies, liability policies, and other policies, as opposed to cyber-specific forms. And I think in the coming months and years, we're going to see a lot more decisions under cyber-specific policies. So that's both interesting and I think important cases for our viewers to be aware of. Thank you, Shane. Over the past 3 episodes, we've covered a lot of ground, from opioids to lead paint to environmental to fax blasting to ransomware. So you're truly an insurance reporter for all seasons.
Thank you, Scott.
Our thanks once again to Law 360 Insurance Authority Senior Reporter Shane Dilworth. To keep apprised of important case rulings and developments in insurance coverage law, keep up with Shane at Law 360 and keep up with us at Hinshaw Insurance Law. As always, we thank you for joining us and invite you to tune in or click on for your next episode of Insurance Law.
The information on our insurance law program is provided for general information purposes only. Nothing stated on the program constitutes legal advice or creates an attorney-client relationship. You should consult directly with an attorney of your choosing if you'd like to obtain any advice with respect to any claim, case, or matter. Any views expressed are those of the guests and are not necessarily the views of Hinshaw Culbertson or any of its clients. For information on past and upcoming programs, visit the Insurance and Reinsurance page on www.hinshawlaw.com and click on Multimedia.